Morning, everyone. We are just going to wait a couple minutes for a few more people to sign on, and then we'll get started. Still have a few other people joining here. How's everyone doing today? Just for all of you that are signed on, just kind of a little intro. You are going to have the opportunity to ask questions. You'll see over on the right, you have the opportunity to do that if you want to ask questions. We're going to try to answer as many as we can with the time that we have left over at the end. Just so you can see, I'm not sure how familiar you all are with this platform. Here's our PowerPoint, opening slide. I hope you can all see that. And with that, I think I'll get started. Good morning, everyone. My name is Christian Nickerson. I'm an attorney at Greene Broillet Wheeler, and welcome to the webinar on the Sanchez versus Durham School Services case. First of all of us here at Greene Broillet Wheeler would like to thank you for spending your morning with us. This webinar is part of our Method for Success program, which we're doing bi-weekly, which we are offering to talk about some of the interesting cases that we've had, interesting and challenging cases, and the results that we've had and how we won them. And we hope that helps you in your own practice. Today we're here to talk about a case, which I'm sure you saw from the promotional materials, involving an elementary-aged girl who was hit by a vehicle as she was trying to cross the street in front of her grandparents' house to try to get to her school bus. Although this case presented a lot of challenges, which you're going to hear about today from Jeff and Ivan and myself, we were able to obtain a $36.1 million verdict in San Bernardino County for a little girl who really, really needed that and whose life really depended on it. This case we feel is a case that defines what our firm is all about. And we hope that you take a lot away from this presentation. And even if you don't have a case that necessarily involves school bus safety, we feel like we're going to cover some principles today that'll be very helpful and applicable in almost any personal injury case. So we hope that you find this interesting. Before we get started, I'd like to tell you a little bit about each of the presenters. As I said, my name is Christian Nickerson. I've been an associate here at Greene Broillet Wheeler for about 10 years now. I was heavily involved in the case during the discovery phase, doing depositions, written discovery, working with experts, informing theories, working with Jeff on that. But unfortunately, we had to move in the trial date, and it conflicted with my wedding date. So Ivan jumped in and did a fantastic job, and happy to report that I'm still happily married, and obviously we got a great result in the case, so everything worked out. And with that, I'll introduce Ivan, who you see there in the middle on your screen. Ivan's been a great friend and colleague for many years. He's had a lot of tremendous results, verdicts and settlements. He's won numerous awards, all of which you can read about online. And Ivan really jumped in on this case, as I said, because I was back east getting married, and did a phenomenal, phenomenal job. As I mentioned, a $36.1 million verdict working with Jeff. And I think one thing that'll shine through in this presentation is the real passion that Jeff and Ivan had for this case and getting justice for this little girl. And finally, we have Jeff Wells, who I think a lot of you probably already know, and a lot of you have probably already heard speak. Jeff has won many awards. He's the former president of CALA, still very heavily active with CALA and with CAOC, doing a lot of work for all of us plaintiffs' lawyers and protecting the rights of our clients. He's been a tremendous mentor and friend to me for many years. And as I mentioned, I think you'll see his true passion for this case and getting full justice, as he likes to say, for this little girl. And with that brief introduction, I'd like to turn it over to Ivan and Jeff to start the presentation.
Good morning, everyone. Thanks for joining us. This was a 2-month trial out in San Bernardino, and I think Jeff and I learned a lot during the course of the trial, and we hope that you pick up something from today's webinar. So thanks for joining. I just want to point out that the PowerPoint that we're going through is mostly from our closing argument, and that's posted, so it's available to you if you don't want to take notes. And also the reporter's transcript from the closing arguments that Jeff gave is also going to be posted. And if we cover anything else, like a motion in limine or a trial brief we mentioned, that you're interested, just reach out to any of us, and we'd be happy to get you those materials later. So I'll turn it over to Jeff to kind of set the stage and tell you all what this case was about.
Okay, thanks, Ivan. If we could pull up the first slide, I would just start out by kind of going through the facts. And I want to give a shout out to Andy Bisseri. He was the lawyer that referred us this case. And the case initially came in as a little girl darting out in the street, hit by a car, thrown 70-some feet in the air and lived. And we had to figure out what the heck are we going to do for theories in the case. And I'm going to set the scene with you here. These are the key points in this case. So you have the Gaussine house. You have the red X. The red X is where Miss Gaussine and her daughter were also walking across the street with our little girl, Isabella Sanchez. The red arrow depicts where the point of impact was between the car coming from right to left to hit her. Down in the bottom left corner is the bus stop. That's where the bus would come around the corner, take a right on, this is 9th Street, right on 9th Street and stop. And then, of course, you have the Sanchez house. That's where Isabella's grandparents lived. The reason why I want to go through this is because I want you to be able to think about in your own practice with your own cases, issues that maybe you hadn't thought of that would help you prepare one of your own cases. In this case, we had to look at a number of different possible defendants. First case, obviously, is the car. The car had a minimum policy, 5100 policy, not going to go very far there. Then we looked at the road design. If you can see, there's a dirt sidewalk on the top of the exhibit, and then on the bottom there's a concrete one. That dirt sidewalk, very unsafe, very difficult for people to navigate. And what they were supposed to do is they were supposed to walk down the dirt sidewalk to the intersection you see on your left-hand side. There's a traffic control light there. Cross at the traffic control light and then come up to the bus. That's what they were supposed to do. Nobody did that. But we did file a government claim on the road design, got the SWITers, got all the discovery, and turns out no prior accidents. We have the school district. The school district picked the bus stop location on the other side of the street. There were 4 kids that crossed at this bus stop location. There were 4 kids that were picked up. They all had to cross the street. If you look at the green line that's across 9th Street, that's the path of travel that everyone took every day. And that ends up developing into our best theory in the case, by the way. So the green line coming across the street and then walking down to the bus stop. So we also included the bus company. The school bus company was called Durham. They're a private company. They're one of the largest school bus companies in the country. They contract out with school districts. And the important difference is the school bus company does not pick the location of the school bus stop. That is done by the transportation safety person from the school district. So you realize you got to have both of them in at least. And one of them has a government tort claim and one of them does not, right? So you got to be sure and be mindful of that government tort claim for the school district. And they're the 6-month claim in California we have. And so that's kind of the overlay of the different defendants. As time went on in discovery then, we got rid of the government entity on the intersection. The school district gets out on summary judgment saying no duty because the accident did not happen at the bus stop. It happened 150 to 200 feet down the road across the street, and therefore no duty. So we go to trial then with the car, this trucker, and the school bus company. Those are the players that we have involved. If you think about when you get a case initially comes in, you might look at that and go, well, I don't know if all those defendants, bring them all in, because you don't know what the facts are going to develop. And you're going to see what the facts developed in this case that could help you in your case. If we could go on to the next slide then. So we developed two theories. And the two theories were what's called the eyes and ears rule. And that eyes and ears rule pertained to the bus driver. So the bus driver and the bus driving company, she's in course and scope. Her name was Shanita Mason. Eyes and ears rule is very simple. If you see something, say something. If you see something unsafe, you must say something. And you must report that right away. The second rule was the red light rule. If you're stopped at the bus stop, you must turn on your red flashing lights right away. That's the vehicle code in California. That's the law probably in every state. And so those are the two theories of negligence that we pursued in this case, even though our little girl wasn't struck at the bus stop. Okay, if we could go on. So one of the things that would happen during the depositions is that there are three moms that testified in this case. There were all three eyewitnesses. One was named Galcine. She was going to cross with our little girl, and our girl unfortunately says, "There's my bus," and she breaks free of her hand and she darts out. Within 3 to 4 seconds, she's hit by a vehicle at 38 miles an hour and thrown 78 feet. But not only did they cross a jaywalk mid-block crossing during the morning, but they also were left off in the afternoon. So you have a bus case. Think about if there's unsafe practices that the bus driver should be observing and reporting. It's not only the pickup in the morning, it could be the drop off in the afternoon. In this case, this is an actual trial exhibit where I had one of the moms. There were two moms that were at the bus stop and then one that was crossing the street. I had them draw on the diagram how they got home in the afternoon on the drop off. And there's the diagram. We called it a jet stream. It looks like a jet stream. That circle is the bus stop. So they all would cross mid-block. Nobody used the traffic control light. And this is very important because the question was, where was the bus when you would cross the street to go home in the afternoon? And they all they were sort of hostile witnesses to us, and we're going to talk about that, but they all agreed that the bus was at the bus stop, and they crossed in front of the bus stop almost every day, in front of the bus almost every day. That gives you the notice of the eyes and ears rule that became our main theory in the case. This is a view then, to finish the scene, this is a view from the bus driver looking across. And it's very important, that white mailbox that you see in the middle of that screen, that's where they would all stop and wait for the bus to get to the corner or to the bus stop before they'd cross. And we knew the bus driver, because we had taken her deposition, she was going to say she never saw anyone jaywalk. They never saw it. Every day, never saw it in the morning and never saw it in the afternoon. This driver was a new driver. She had worked there for about a month. So this is her view from her driver's window, that we got a bus out there and took pictures. I'm going to give Andy Bisseri credit on that. He's the one that got the bus out there and took this photograph right here was a very good photograph. Okay, if we could go on. I'm going to push over to Ivan now to talk a little bit about the red light rule.
So just an overview, the red light rule is based on the vehicle code section that applies to buses that requires them, whenever they're stopping to load or unload pupils, they have to have their red light system engaged. It's flashing, and the little stop sign that you see in the picture in the bottom that's on the side of the bus, that arm, it has to pop out at the same time. It's part of the same system. So the drivers see the flashing stop sign, they see the red lights. And you can't wait until the kids are lining up. You have to do this the second you stop. So in this case, there was conflicting testimony as to whether the red lights were on at the bus, or even that the bus was stopped at the time that Isabella ran across the street. But there was testimony that the bus had been there from at least some witnesses for a period of time before she said, "There's my bus," and ran across the street. The reason this is important is because the driver Vo is coming from a direction. Here's the perspective that Ms. Vo would have had. If you look in the middle, there's a circle around the point of impact, and to the left of that circle, that's where the bus stop was. So from 300 feet away, had the bus had the red lights engaged and the stop sign out, she would have had a chance to see that, perceive, react, and slow her vehicle down enough to avoid the collision with Isabella. The difficulty in this theory, and it really was by far the more difficult of the two theories in the case, was that Ms. Vo testified in her deposition that she never even saw the bus at the bus stop. So we had to show using human factors that had the lights been on, it would have grabbed her attention and she would have been able to perceive that the bus was there. We hired Dave King to do an accident reconstruction, and this is just a quick summary of it. Based on a perception reaction time that Joel and Gil, our human factors expert, provided him of 1.1 seconds. That's a perception reaction time to an expected event to an unexpected event would be 1.1 seconds. Dave King calculated Miss Vo's speed to be 38 miles per hour, and that's based on the fact that Isabella was thrown 78 feet after the impact. So had Ms. Vo been able to see the red lights, the stop sign on the side of the bus from 350 feet away, she would have had time to perceive, react, and she would not have had time to stop to avoid the accident, but she would have slowed her vehicle down enough that we had an avoidance scenario where she slows down to 28 miles per hour by the time she gets to the point of impact, and Isabella would have already been past Ms. Vo's path of travel at that point and would not have been struck by the vehicle. So this next slide is a rules of the road board that we put together on a poster board and used with almost every witness at trial. And I'll turn it over to Jeff to give you our thinking on this board.
Okay, so sometimes, keeping things simple is the best way to go. Rick Kramer does some very elaborate boards, but this was a Rick Kramer board that was a large board, oversized board. We didn't want it up on the PowerPoint or anything. We wanted that physically in the courtroom. And we came up with rules, and I'm going to also give a shout out to Rick Friedman's book, Rules of the Road. And if you don't have that book, you should get that book. It'll help you in your practice to develop rules on the road that apply to almost every case, but they definitely apply to every auto accident case. And we came up with the rules that we would be able to show the witnesses for the defense, the PMKs, the supervisors, the bus drivers, all those people, that it would be undisputed that they would agree with every single one of these rules. And so the eyes and ears rule, the bus drivers, the eyes and ears out at the bus stop, every witness, we pull this board up and the jurors, they got it, man. And they listen to it. So think about the second rule, be vigilant. The most dangerous time is getting students to the bus stop and from the bus stop. One of the things we had to create, and I would suggest that you have to think about this in your own cases, we had to expand the area of the environment, what I would call the unsafe environment, beyond just the bus stop physical location itself. The defense kept saying, hey, she wasn't hit at the bus stop. She wasn't hit by the bus driver. Why are we here? Why is this a case? Because the unsafe environment is part of the bus stop. It is. And the drivers have a duty to look, and this is the important thing that came out of this case, to the bus drivers all across the United States and maybe the world, because they have these rules all over in Europe as well. And that is, if you see something, you must say something, but you can't just have tunnel vision and looking just at your bus stop. Oh, Mikey's playing around at the bus stop, I'm going to ride him up. You got to look. If you have parents that are jaywalking, running across the street, and by the way, this street, this 9th Street that they crossed, 40-mile-an-hour speed limit, 40-mile-an-hour speed limit. These mothers and these kids are running for their life every day across this street. And they did not really appreciate the hazard I don't think, until after this accident occurred. But boy, the bus drivers, they have training on that. And we knew about that because we got their training videos, and we're going to show those to you later. They knew about looking at the environment. So think about, in your case, try and expand it a little bit, not just a microcosm of where the bus stop is or the bus is. Look at the whole environment. You got to go out to the bus stop location yourself and look at it, which we did numerous times. Number 4, you got to enforce the rules. If the parents are jaywalking across, running across the street, not using the traffic light, they had rules for that. If they did that, the rule was, if you do it, you're going to get a warning, and if you keep doing it, you're losing your bus privileges. Is there any question on that? You're going to see how we used those rules. And then, of course, 5 was the vehicle code section that we used, that you must turn on your red lights. And that was very important here. And you're going to see why, because the bus driver gave a statement to the police at the scene that she doesn't turn on her red lights until after all the kids are lined up. And we're going to see how that plays out. So this Rules of the Road is a big exhibit. It was bigger than 30 by 40, one of our best exhibits in the trial. Figure out rules of the road for your own case and use them. Okay, so this is the actual trial testimony now we're going to show you. This is a clip, by the way. If you videotape the depositions of some of the key people on the other side, you're then able to take a screenshot of that deposition, and you can pull it up and use it in your closing argument PowerPoint. Because when you're in trial for 2 months and then you go to give your closing argument, I mean, sometimes the jurors can't even remember who some of those witnesses are or what they look like. And here we had the picture of them. So we would pull up that clip and say, here, Corey Cohen, you remember her? Here's what she looked like. And she was the head Durham training and safety supervisor. Let's look and see what her trial testimony was on the rules of the road. You know that the rules are for the bus driver: reporting jaywalking, mid-block crossing. And by the way, throughout the course of the case, we used the term mid-block crossing, and the defense used the term jaywalking. I just felt like it would help lower our negligence on our people's behalf if we use the term mid-block crossing instead of jaywalking. Think about that in your own case, how you might want to use the term. So we would use those terms, and then when we would read them back sometimes in the depot, it would be mid-block crossing instead of jaywalking. By the end of the trial, the defense was using the term mid-block crossing. Anyway, I used it here for both. And I said, you're not using a traffic light. You know what the rule is. They got to report it, right? Yes. Next trial clip. Is there any question in your mind that the bus driver can say, you know what, it's no big deal? No, we have a standard, and any safety violation, they're required to report it. This is basically setting the standard of care through the witnesses of the defense before we ever had to call any experts or anything. Okay, next. Here's the actual bus driving. She's now a field supervisor, but she was the woman that trained our bus driver, Mason. And we went through the rules with her, and she spelled it out. Look at her trial testimony. Next slide. Is it true that you rely on the bus drivers to be the eyes and ears of the field supervisor? Yes, that's correct. And they're supposed to be vigilant. See how we took the testimony. We had this testimony in the depots too. We took that testimony from the depots and made it into our rules of the road. Then we got them to agree with us. And it's setting the standard of care through the defense witnesses. Next slide. You agree it's unsafe to cross 9th Street and not use a traffic control light? Yes, it's dangerous. It's so obvious. You agree your drivers, they're supposed to see that and they must report it? Yes. Isn't it true that the most dangerous time for students is when they're off the bus? Now, we had all these rules from the video training videos, so we knew the answers to all these questions, by the way. And the most dangerous time is getting to and from the bus stop. Yes. So we're expanding the area from just on the bus and at the bus stop to the area beyond that, to the environment, so that they are in agreement with us that it is the environment that's got to be watched. Next. is the bus driver, and if the bus driver is at the bus stop and the parents are crossing right in front of the bus driver across the street, is she supposed to see that? Yes. Are they supposed to be vigilant? Yes. Now, the great part of this testimony was we had already had the 3 moms testify that they crossed in front of the bus driver every day. We'd already had that testimony in front of the jury. So when the bus driving person comes on and we say, hey, this, you know, aren't they supposed to report this? The evidence started to really build with their own witnesses about their own negligence. Next. And then I gave her a hypothetical. I want you to assume in this case the testimony is for the whole month of August. So school started beginning of August, and then they had a whole month of September. Our accident was October 2nd. And one of the most simple exhibits that we're going to get to, we put up, was a calendar. Rick Kramer prepared a huge calendar showing all the opportunities that these drivers had to report this unsafe conduct and correct it, and they missed it. As a result, we have this horrific accident, even though it's across the street. And so what does she say? I want you to assume it happened. Is that dangerous? Yes. Would you expect your drivers to report it immediately? Yes. Is there any question on that? No, this is trial testimony, standard of care, and then it gives us causation too. Okay. Then we had one of the best witnesses was the head of the school district. I'm going to hand that over to Ivan.
So Maria Espinoza, she was the transportation director for the district. Some districts have their own buses to transport students, but in San Bernardino, they contract all of that out to Durham Bus Services, our defendant. So originally, when she was deposed in the case, she was adverse to us because the district was still in the case at that point, but she actually gave us the best testimony in the case in terms of the standard of care and the expectations that the school district had of Durham, of the bus drivers, in terms of being vigilant and reporting anything that they saw. So we asked her, does the district have feet on the ground at the stops to try and observe unsafe conditions? And she answered, yeah, there are eyes and ears out there. So that was really our theme of the case. And Christian actually took her deposition and did a great job getting all this standard of care stuff pinned down. And we took that eyes and ears phrase that she used and made it our entire theme of the case. But it was coming from her. And I actually spoke to her the day before her testimony when I was going to put her on the stand and reminded her of her testimony where she mentioned the eyes and ears, and she was kind enough to repeat it at trial. So we just keep going back there. And the next question, when you say the Durham drivers are your eyes and ears, there it is again, tell the jury what you mean. So she explains that they're the ones that are there every day. And she said they see the kids, they drive the route every day. In other words, they rely on the Durham drivers. I asked her a hypothetical and to assume that the first graders were jaywalking across the street every day for 2 months, and this is evidence the jury already heard and knew was true. Would you expect a vigilant driver to observe that? Answer, absolutely. Question, and if the driver observed that, is that something you would expect to be reported? Answer, yes. And then when asked if they ever made any reports about any of these jaywalkings or mid-block crossings that went on for 2 months at our bus stop for the first 2 months of the year, she confirmed that she had looked and no reports had ever been made. So in terms of causation, we had to show that had reports been made that the school district would have taken some action that would have affected the parents' behavior, right? Because the defense was claiming, so what? Even if this was reported, you had these parents that didn't care about crossing in the middle of the block. They would have just kept doing it anyways, like they did every day. So we had to get into the issue of progressive discipline, and Maria Espinoza was really strong on that. She talked about a 6-step process they have with the school district to discipline parents if they don't follow the rules. And if it's a serious violation that could lead to harm or death, they can actually skip to the most drastic step, step number 6, which is revocation of the bus pass. So we were able to argue these parents, if they knew they were going to have their bus privileges revoked for their children, then they would have changed their behavior had it been reported and the progressive discipline took place. A lot of these parents work. They couldn't, they didn't have the time to take the kids. So it made sense that they would be responsive to that discipline. And then we asked Ms. Espinoza, in your experience, the process we've discussed, the progressive discipline, does it work? Yes. So there's the causation right there on the reporting aspect of the eyes and ears rule. But there were a lot of causation issues in the case. This was one of them, but there was a bigger overarching causation issue, probably the biggest issue in the entire case. I just heard Jeff laugh, which was this, and it kind of comes through in this testimony. Here's the testimony of Ms. Galcine. She's the neighbor who Isabella's mom entrusted to walk her daughter across the street along with Ms. Galcine's daughter. So the two girls are on either side of her, and at the time, Ms. Galcine isn't holding Isabella's hand, but Isabella is holding Ms. Galcine's arm. And Isabella said, question, there's my bus? Answer, she said, my bus. Question, and then did she take off running as soon as she said my bus? Yes, that is what happened. So it's a dart out case. She's an impulsive 6-year-old girl. She sees her bus and she darts out. And the main defense in the case was, well, even if we violated the eyes and ears rule, even if we weren't vigilant, even if we didn't report anything, even if all that's true, we didn't cause the 6-year-old girl to just impulsively run across the street to her bus and get hit by a car. We didn't cause that, so there's absolutely no causation. In the middle of the trial, after we rested, there was a motion by the defense.
Directed verdict.
Motion for directed verdict. We had a 2-hour hearing, and the defense was, arguing their point that they didn't cause her. And Judge Pacheco, who's a fantastic judge, by the way, he's sitting there nodding his head and with them. And when they're done, he's looking at us to see our explanation of how they caused her to run across the street. And what we argued in the case was, look, all the adults created the path that Isabella took that day. The parents, the bus drivers, the bus company, they allowed the path to exist right through the middle of the street, not a path using the light signal. So basically, we argued they created the path that she took when she darted out. Had they not been negligent and not created this path across the middle of the street in the first 2 months of the school year, she would have seen her bus and she would have ran to the intersection and used the light if that had been her custom every day. So as we were explaining this, we got by the motion. Judge Pacheco actually was with us, and he said, so it's kind of like a jet stream. And I think Jeff actually adopted that term and used it in his closing. It's like a jet stream with kids going back and forth every day. And ultimately, they created the path. And as Jeff will talk about later, the jury actually found no percentage of fault on Isabella at the end of the case, because it was the adults around her who did create the path that she used to get to the bus that day. So here's a slide of the 3 moms. And Jeff, why don't you talk about how you approached their testimony at trial?
Okay, so the 3 moms, we called them. By the way, the order in which you call witnesses sometimes is very important. Not sometimes, always very important. In this case, we called the bus driver as our first witness because we knew that she was going to dispute what was in the police report about her not turning on her red lights until all the kids were lined up. So we got that testimony from her. The defense decided to defer her kind of rehabilitation till later on in the case. So, okay. So then we called the 3 moms. And by the way, I'm just going to set the stage. These 3 moms were hostile witnesses to us. Galcine, who was the one that was crossing with the 2 girls, and then Arana and Marin were already over at the bus stop. And they saw the whole thing. They're looking across, they see the whole thing. So in the police report, Arana and Marin say that the bus is at the bus stop at the time of the accident. And then when we take their depositions, they deny that. Okay, so that's a big deal. So they say the bus, one says the bus was at the corner, one says the bus wasn't even at the corner yet. It hadn't even made the right turn. That's what they said in their depositions. So we knew we were going to have to call in the police officers that took those statements to impeach them later on. Now, fortunately for us, not only did they have the written statement, they also had digital recordings of their statements to the police officers that were exactly what was in the police report. So first, Gaucine, she did not like our little girl's mother or the grandparents. She felt like our mother was irresponsible because she was dropping her daughter off at her mother's, the grandmother's house to take her over to the bus stop. The reason our mother was doing that is because she got a job as a supervisor at a Subway, and she had to open up the store at 7 a.m. and the bus didn't come until 7:42. So we were able to show, you think about some of the things you want to present in your case about who your clients are. Here's a woman who's a hardworking woman. She has 3 kids. She's a supervisor. She has to take care of this situation by adapting to her job start. So she takes her daughter over to her mother's in the morning, drops her off, and then grandma was supposed to take her across the street. And that happened for about a couple of weeks until grandma got a job where she had to start at 7:25 in the morning. And so then what grandma would do was have the little girl go over to Gaucine's house in the morning at about 7:20 and then stay at her house, and then the 3 people would cross together. That's what would happen. Now, Gaucine denied that the grandma had made that arrangement. They tried to make it sound like grandma just let this little girl run wild. And then, of course, because they didn't like our mom and the grandma, they put in the police report our little girl had crossed 9th Street numerous times by herself and didn't look both ways and ran to the bus stop. That was bad testimony for us, okay? So I had to ask permission from the judge to treat these as hostile witnesses under Evidence Code 776 and cross-examine them. And I said to Ms. Gaucine, hey, so you're critical of this mom because she wasn't crossing her daughter. That's right. And you're critical because her daughter crossed the street and jaywalked across the street. That's right. Well, where did you cross the street? What do you mean? Well, where did you cross the street when you went to the bus stop? Did you go down and use the traffic light? No, never. Okay. And so what ends up developing actually during the trial was proving our theory that the mothers and the kids did not appreciate the danger of jaywalking across that street to get to their bus stop. And if they did appreciate it, they never would have risked that for their kids or for themselves, right? They would have gone down the traffic light every day. They didn't appreciate that danger until when? Until, as Gaucine says, well, I understood after this accident, okay? So there you have it. Now you have the situation where you're polarizing the case, and I'm going to give another shout out to Rick Friedman, polarizing the case. What did the bus company and their drivers know that these mothers didn't know? They knew about the hazard of jaywalking to get to the bus stop. They appreciated it. They were trained on it. They had tested on it. We had a video showing that they learned about it. And the mothers, guess what? They didn't have that training. So I was able to show the difference between what these mothers knew and what the bus company knew, right? And so that's what you want to do in your case. You want to polarize that case, and you want to make a distinction between what they knew and what your mothers knew. And any parent, and I'm a parent, any parent would never take that risk if they really appreciated that hazard of running across that street with cars coming down there 40 miles per hour. All right, so let's go to some of the testimony then of some of these witnesses, if we could. You can see how this lines up. So this is a woman who's standing at the bus stop. She testifies in her deposition that the bus wasn't there, even though she testified in the police statement that the bus was there at the time of the accident, okay? So I had to go with them about the path of travel because they wanted to criticize us for jaywalking and blah, blah, blah. And by the way, our mom, Karina, had taken her daughter, jaywalked her daughter, mid-block crossing with her daughter the year before from her mother's house. So I knew we were going to have to accept some responsibility on behalf of mom for setting that, as Ivan said, setting up that pathway for these kids. And, you know, the improper pathway, an unsafe pathway. But we're going to have to accept some responsibility. So we do that at the end of the case. So I asked her, can you just show the jury your path of travel that you took your David to the bus stop every morning? Well, and then she draws that line right across there, right? Go to the next one. Here's from her deposition. She had already drawn it. So she lived in a back house behind the Gaucine house. She had a friend that would come over, park her car, and believe it or not, on the Google map, there's a red car parked there. That's actually her friend's car that was showed in that photograph. Her friend would come over in the morning, walk back to her house. They would have, you know, coffee or whatever. Then they would come down to the mailbox. They would look to see where the bus was at the bus stop or taking the corner. Then they would cross right there. Okay, so this is a trial exhibit that we used and a part of the jet stream, of course, part of that pathway. Next slide. Did you ever go down and use the traffic light? No, never. Is that correct? Yeah, never. See, and so I'm setting up recognition of these moms early on in the case. They don't appreciate the hazard. And if you think about it, it's common sense. They didn't. Next. Would you wait to see? So now we want to see, where were you when you would cross? Where was the bus? Where would the bus be when you'd cross the street? Because guess what? If you could see the bus probably could see you, right? So would you wait to see the bus at the corner, at the flashing its lights, and then would you cross the street? Yes. Okay, so that was good for us, but it wasn't great. And where would you stand? Well, we would stand when it's blinking lights. Sometimes I would stand in the dirt, like in the driveway. Sometimes on the side of the dirt. That's by where that mailbox was. Next. And then I pushed her a little farther because I could see that she was going to agree to this. Did you ever have times where the bus was already at the bus stop while you were crossing? Look at that answer. Yes. And we have that great blow up showing the view from the bus driver crossing the street. So now we have the eyes and ears of the, you know, if she can see the bus stops at the bus stop, the bus driver knew or should have known that she was crossing there mid-block. Next. Again, I had her draw on the diagram, path of travel. You would come home and you would be dropped off, and this is where she draws this circle. You would just jaywalk right across the street, go ahead to that circle. She drew this with the orange marker right in front of the jury. The circle's the bus stop, and the jet stream is the path of travel to get back home. And there it is. And the bus was at the bus stop most of the time when she crossed with little David right in front of him. Okay? Next. More testimony. Did you cross in front of the bus every day on the way home when you crossed 9th Street? Objection, leading. Yeah, it is leading, but I had her as a hostile witness. Yes. And every day you would walk across 9th Street right in front of the bus driver. Is that right? Yes. Now this is really important too, because the bus driver had testified before these ladies, and the bus driver said what? She said, I never saw it. It didn't happen. If they would have done it, I would have reported it, right? And then these women all came on after that. So now the defense decides to call the bus driver later on when they start their case. And they're talking about how she was this nice girl, woman, 26 years old. She went to Liberty University. She was Mother Teresa of bus drivers. She reported everything. If there was kids using bad words on the bus, she would report that. And if the insinuation being if there was anything that would have been unsafe, she would have reported it, right? So first question, well, you were here. They had her in the courtroom too, by the way, most of the trial. You were here when the 3 moms testified that every single day they crossed the street right in front of your bus, right? You were here for that, right? Yes. So they're all wrong and you're right. Is that what you're telling this jury? And you could hear the air go out of the room and the case changed right then. And she said, that's right. That's what I'm saying. Okay, just want to be sure. And of course, no one believed that testimony. Next. So here is our calendar, and we were able to use these with the witnesses. Remember, our bus driver, she came on in September, so the whole month of August was another bus driver. He had left the bus company. We couldn't get a hold of him. He was evading service. He moved out of state. So that's another reason I tell people, when you have these cases and you have a bus driver, name the bus driver as a defendant in the case. Because what happens is 2-3 years from the accident date, you go to trial, they're not there anymore. What's going to happen? They're going to say, oh, we can't produce them. We don't know where they are. And they don't work for us anymore. If they're a named defendant, the lawyer has to produce them. So we use this to show the morning and the afternoon. Another Rick Kramer blow up right here, huge board. And it was just how many chances did they have to correct this situation? And they didn't. And now this 6-year-old wonderful girl is in a wheelchair with a trach and a feeding tube with massive brain damage the rest of her life. Okay, next.
Jeff,
Yes.
let me ask you a question. In a lot of our vehicle cases, we get a situation with multiple defendants, and one of them has a minimum policy. In this case, that was Ms. Vo, who had the minimum policy, who hit Isabella.
Yes.
Could you just talk a little bit about your thinking in terms of the decision to keep Ms. Vo in the case through trial?
Yes. So this is an issue that comes up frequently. Should I take the money, the 15, or in this case it was a 5,100 policy? Should I take the money, let that person out, or should I keep them in? I think you should, most of the time, you should keep them in. Here's the reason why. Their insurance company is going to be required to defend them. They're going to have their own lawyer. They're going to have a person that's going to stand up and say their client didn't do anything wrong. And it's going to be a very awkward thing for you to get up there and say, and by the way, the car that hit our little girl, we're not really blaming her because, you know, she didn't have time to perceive and react. She didn't do anything wrong. It doesn't look right to the jury, in my opinion. So that's number one. Number two, the reconstruction will show that very little time to perceive and react. The driver, in this case, the driver of the car was a very good witness. She not only cried on the stand, but, you know, we, as Discovery shows, she had her own daughter in a car seat in the back of her car when this happened. I mean, can you imagine the trauma to this woman that's cried and seen nightmares of this for years after this accident? You know, she had to finally forgive her. I actually talked to her and a lawyer after the case and said, you got to let this go and forgive yourself, move on with your life, ma'am. You did nothing wrong. But the reality of it is she's a victim of the negligence of this dangerous environment too. And so it helped, I think, our whole case to show that, you know, not only was our whole family trashed, but this woman's life was destroyed too. And she was a victim of people not following their own rules. And that's a result of look what happened as a result of that. It's terrible. So those are my thoughts on it. This was a slide that I'm going to give a shout out to Ivan Puchalt, who created during the trial while a witness was on the stand when we were talking about the jet stream and the bus. And you can see that we took this off of their video. It was a still, and you could see where the bus is and the view and the line of sight. And if you could see the bus driver should be able to see you. I mean, the evidence on that has started to become pretty overwhelming, in my opinion, my unbiased opinion. Okay, move on to the next. And then again, that view from the bus driver, you see the mailbox, you see the dirt part of the sidewalk there. They would stand there and they would cross right in front. And again, line of sight of the bus driver, I mean, beyond a reasonable doubt. Okay, and then just by the way, in order to get the pictures into evidence, you got to authenticate those. We had to authenticate this picture with the bus driver. She was really the only person that could authenticate this picture. And we asked her, is this picture, is it looking down? Do you see it? Yeah, does it accurately depict the view you would have had when you were stopped at the bus stop? Yes. Bang, we get that into evidence right there. Again, Ms. Galcine, we're going to give an example here of just how to use, I think, is this where we have the recorded statement?
No.
Okay, oh, okay. Here it is. Here, when we're talking about appreciation of the hazard. So the truth is, you never once, when you were taking your child to the bus stop, ever went down and used the traffic control light. Is that true? The truth is, I didn't. Okay. Next slide. This is one of the women now that, this is where she said she would cross. So she's one that's at the bus stop at the time of the accident. She would cross right by that mailbox. And there it is, there, the jet stream. Next. Can you recall a situation where you ever used the crosswalk? No, never used it. Okay, and this is just more things. Now this, I'm going to shoot this over to actually to Christian. Christian worked on getting this bus video, and tell us a little bit about how you did this and how it worked.
Sure, thanks, Jeff. We got these training videos, which proved to be very helpful in the case because the defendant was setting their own standard of care, but it required a battle to get them. A lot of meet and conferring. I believe our first request, they produced a video that dealt with safety of kids on buses. So obviously that was not really our case. Our case is about the safety of kids going to and from buses. So we said there's got to be more here. You're going to have to produce more. It was a battle going back and forth between defense counsel. And finally, we came to the resolution. They said, hey, we've got about 20 hours of video. Come out to our facility in the desert. We'll put you in a little room. You can watch as much video as you want, and we can talk about it later. So I did that. Went out and spent a whole day out there watching these videos on VHS tapes. And ended up being worth it. So after we watched the tapes, I remember sitting there thinking, wow, this is great stuff for our case. So Ivan's going to play a little clip for you right now.
We'll play it here, and you'll see why they did not want to produce this video.
Today, we're going to talk about safe bus stops. As a school bus driver, you must be able to spot an unsafe bus stop. You also have to watch out for situations at a normally safe stop that can make it dangerous. You see, children are at far more risk before they board the bus and after they leave the bus than they are while riding. In fact, 5 times as many students are killed outside the bus than on the bus. So the safer the stops, the less likely that the students will be at risk. Once the students are on the bus, they are extremely safe. The risk is before and after the journey. Safer stops reduce this risk. In this course, you'll learn to identify bus stops that could potentially be hazardous. As a driver, you're best equipped to observe and understand what occurs on your route. The school district chooses the bus stops, but you're the one who's out there every day, and your feedback is essential for keeping the route safe. It's important to speak up if you think a bus stop is unsafe. Even though we can't fix every problem on every route, your feedback and advice is valuable. The district may be able to change the stop, but they can only do this if they're aware there's a problem in the first place. During this course, we'll also examine some of the diversions and temporary hazards you may confront, which can make an otherwise safe stop temporarily dangerous.
So great job getting that video, Christian. That was basically our whole case, that bus drivers need to be vigilant and see what's going on outside the bus at the bus stop, not just on the bus. So here is the red light rule. I'll just walk you through some of the evidence that we were able to present at trial that supported our theory that the bus was there, and had it been there, a red light would have made a difference. That's the vehicle code again. We already talked about that. It just requires as soon as the bus driver stops, they have to pop out the stop sign and flash the red lights. In the police report in this case, Ms. Mason, the driver, she made a statement saying that she doesn't activate the red lights until all the children are at the bus stop and ready to board the bus. So that was her custom and practice, and it's a complete violation of the rule that we just looked at, that you have to flash the red lights as soon as you stop. You don't wait for the kids to board the bus. So the way Jeff approached this at trial is first we called Shanita Mason before the officer, and we were able to read her statement directly from the police report. I think it came in as a party admission. That was another advantage to having Ms. Mason in the case as a party, because her admission in the report came into testimony. And she denied it here. Jeff asked, Mason said she doesn't activate the red lights until all the children are at the bus. Did you tell Officer Cruz that? No. Answer, so she denies it. And in fact, that's a violation of your rules, isn't it? To wait until the students line up? Yes. So she admits that it would be a violation had she done that. So next we call Officer Cruz. He interviewed all the witnesses at the scene. He had done thousands of investigations before. He was asked, did Miss Mason tell you that she doesn't activate the flashing red lights until all the children are at the bus stop and ready to board the bus? Answer, yes. So here it's coming in for impeachment. Is there any question in your mind that she told you that? No. When you've got an officer in uniform, they're obviously always going to win the battle of credibility. And we got some of the audio statements taken by the investigating officers into evidence too. Here's one from Corazon, Marin. Just try and pull that up.
If you don't know her name, that's fine. The lady that was there with him?
Oh yeah, Andrea. I don't know her last name.
Okay. Andrea. Okay.
With her daughter and the little girl.
Okay. Okay, and you saw them standing here. Was the bus here yet?
Yeah, the bus already is here.
How long had the bus been there when you... Did it just pull up, or had it been there a minute or so, or do you know?
Well, when I was walking there, the bus already was getting there. Like, so he was already parked there.
Okay.
Yeah.
So the bus just got here?
Yeah, the bus just got here.
And Ivan, if I can jump in briefly on that, more and more it's becoming body cam video from the police. They're doing the interviews of the witness statements on body cam. So that can be very powerful evidence in your case, and things that I'm asking for in every case like this.
Great point. Jeff and I just asked for that in a case where it really had nothing to do with liability, but where the police officer's body cams captured just the damages issues, the state that our client was in, who was on a bicycle and had just been hit by a delivery truck. So Officer Donald Rusk was another witness. He'd gone on to become a member of a MATE team, so very specialized accident investigation and reconstruction training. He'd done thousands of accident investigations, and we were able to qualify him as an expert witness and have him talk about his conclusions. The reason we got that into evidence was because he was interested in determining the location of the bus and whether the lights were on at the time of impact, the exact issue we were looking at with the red light rule. The reason he was focused on it was because he had to decide whether to recommend criminal charges for Ms. Vo. If he had concluded that the bus was there with the red lights flashing and Ms. Vo ignored those lights and hit Isabella, then she would have been prosecuted criminally. But he did not come to that conclusion, and we were able to get that into evidence. Here's his testimony. What did you conclude as to the location of the bus based on the witness statements? Answer, based on my training and experience and the statements of all the parties involved, the bus was likely at the stop with its yellow flashing lights on. So if it's there, it's not enough to have the yellow lights on. You have to have the red lights. And also when you do the red lights, it triggers the stop sign that pops out on the side of the bus. So Officer Rusk was on our side of things with respect to the red light theory. Joel and Gil, she provided the human factors in this case. I already mentioned the perception reaction time of 1.1 that she testified to, and she also testified to the fact that Ms. Vo would have been alerted to the bus's presence more likely than not had there been red flashing lights and the stop sign as required.
There's a PowerPoint coming up on yours, Ivan? It's not showing on my screen right now, but.
It's showing on my screen. Is it showing on your screen, Christian?
Yep.
Okay, go ahead.
Jeff, you may need to click one of those green things on the webinar bar, the one that looks like a screen to show the screen.
Okay, will do.
See if you see that. We went over this briefly before, so I won't cover it again. This is the accident reconstruction. Had Ms. Vo had a chance to perceive and react with 1.1 seconds, she would have begun to slow down her vehicle, started braking, and would have slowed her vehicle to 28 miles per hour prior to the point of impact, which would give us an avoidance scenario where Isabella would already be halfway down the street, not getting hit by the car by the time that Ms. Vo's vehicle arrives at the point of impact. And here's another photograph of Ms. Vo's point of view. And again, the red light theory was difficult, but we were representing a 6-year-old girl with a severe brain injury who was going to need help the rest of her life. And our feeling was we had to present every possible theory in the case. And I'm glad we did so. So when Ms. Vo testified, I asked her, what's your understanding of what you're required to do when you see red lights and the stop sign arm, which comes out of the side of the bus? And she said, I would stop. So that's our causation on the red light theory. Had it been there, she knew that she was supposed to stop. So a hostile witness in this case, and maybe hostile is the wrong word because Miss Mendez was the nicest person you'd ever meet. She was a bus driver who was following Miss Mason's bus. And while her testimony didn't affect the eyes and ears rule portion of the case, it absolutely killed the red light rule theory because she testified that the two buses were coming in tandem down the street and she saw Miss Mason turning right onto Victoria where the bus stop was, and that at the moment Ms. Mason was turning, Mendez saw a commotion in the middle of the street, and that commotion was Isabella's body and people starting to gather around it. So if this testimony was believed, then Ms. Mason wasn't at the stop at the time of impact and had no duty to put on her red lights. And she also testified that she was the one who got out of her bus, was actually first on the scene. She gave CPR to Isabella, maybe saved her life or even improved the severity of her injury. So what are you going to do with a witness like this? Jeff gets up there and he would have had the option of reading back some prior trial testimony from other witnesses that contradicted what Ms. Mendez said, because other people said the bus was there. But instead of taking that tact, I thought that Jeff's approach to this hostile witness was just perfect. He got up and he just asked her a couple introductory questions and then thanked her on behalf of the family for performing CPR and offering aid to Isabella. And then he got kind of fired up and said, you know, you're a hero. We need more heroes like you, and asked the jury to stand up and clap for Ms. Mendez, asked the courtroom staff to get up, and next thing you know it, everybody in the courtroom is standing up. They're clapping for Ms. Mendez, and then that's the end of the cross-examination. So I think that the point left with everyone was that she was a wonderful lady, and I think it took some of the sting out of her testimony. Comparative fault, were you going to handle this, Jeff?
Sure. I'll talk a little bit about comparative fault in this case. So with the verdict form that we had, I did want to admit some personal responsibility on behalf of Isabella's mother. I thought it was important from a credibility standpoint to do this. So I admitted 20% on her. I said there's absolutely no way you can put any percentage on Isabella. I mean, we'll talk about that rule, but she's a 6-year-old girl. She's following what the adults have taught her to do. If they had taught her to go down to the intersection, use a light, she would have run down the intersection, used the light. But, and then I said 0 on Miss Vo. I thought 50% on Durham and 30% on Miss Mason, and that's pretty much what the jurors ended up doing for percentages in the case.
And when we were doing the verdict forms, each side had prepared one. I like to always get the defense one first, because if you can live with it, it's always better to use the defense verdict form, I believe, because then they waive any argument that there's error on the verdict form, which, as we all know, is an area that's always ripe for appeal. It turned out in this case, we liked their verdict form, and in fact, it didn't include the neighbor, Ms. Galcine, who was walking Isabella across the street. And we thought that they would want to put some blame on Ms. Galcine, and they didn't. So we were glad to have her off the form. And they also asked for a separate line for Ms. Mason. And we were also fine having Ms. Mason have her own line, because Durham was vicariously responsible for her conduct. And in the end, the jury put a percentage on both Durham and Ms. Mason, which Durham was ultimately responsible for. Here's a jury instruction on the standard of care for minors. We had brought a motion in limine in this case to have Isabella off of the verdict form, because under the law, if you're 5 years or younger, you can't be comparatively negligent. In this case, she was 6 years old, but only by a few months. Had it happened a few months earlier, she would have been 5, and she couldn't have been at fault. And they were really trying to place most of the blame on Isabella, along with her mom. So we lost that motion in limine, but we were allowed to use the jury instruction that children are not held to the same standards as adults, and that the jury was to consider her conduct in light of the same age, intelligence, knowledge, and experience of another 6-year-old. And this was really important because her jaywalking was actually a violation of the vehicle code in and of itself. But there's another really good jury instruction, KC 421, that says that even if you find that Isabella was careful as a reasonably careful child of the same age, that if you find that, then she was not negligent, even if she violated the law. So if she was reasonable, it doesn't matter that she was jaywalking, given her age.
Okay, before we get to damages, if I could just hop in here quickly. So we've got about 20 minutes left in the presentation. We do want to reserve some time for questions. So if any of you have any questions that you'd like to type in to the little box that you're probably seeing on your right in the next 20 minutes or so, we'd love to answer them for you, or try to answer them for you to the best we can. Go ahead, Jeff.
Okay, let's go to the damages portion of the case there. So in a case like this, every case is unique and different and has different issues on damages. In this case, there were 2 main key damage issues at trial. One was life expectancy, because she was so badly injured. She had the subdural hematoma that caused brain damage and affected the right side of her body. So they were going to argue that she wasn't going to live very long. Therefore, even though the care was 24/7, she wasn't going to need it for as many of years. And so that's what we're going to talk a little bit about that. And then the other one was the cost of the attendant care, and Ivan's going to cover that issue for us. If we can go to the next slide. And by the way, people ask, well, did you have your client testify? Should you have your client in the courtroom, etc. This girl, we did not have her in the courtroom. We had her come one day for about 1 to 2 minutes. That was with the pediatric neurologist. witness that could just explain why the left side of her head was injured, but the right side of her body was affected, the motor skills part of it. And that was very brief. And then I was able to, I believe, use that to take away the argument from the defense that this is a case about sympathy. Because I said in a 2-month trial, the girl that's the main focus of this whole case only testified for 1 to 2 minutes. That's not asking for sympathy, but we are asking for justice, and we're asking for full justice and not partial justice for this girl. And so if we could go to the next slide, I did do medical blow-ups just showing her orthopedic injuries. She did have a broken leg, broken arm, broken pelvis. And then if you go to the next slide, we did have a blow-up using a diagram showing the evacuation of the subdural hematoma, and then explain how that all worked. And then we had this chart. So we had the 4 people really testified about life expectancy. We had her treating pediatric neurologist, and then they had a pediatric neurologist. And we had a life expectancy expert, and they had a life expectancy expert. The 2 life expectancy experts, they fight over this thing called the Strauss study from Stanford, where if you are in a wheelchair and you're on a feeding tube and you have a trach, you're not going to live very long. And they have this guy, Dr. Cush. Anybody that ever has a case against him, call me. I'll give you my depot of him. I'd be happy to share that. That guy is, one of the things he does is he makes his own life expectancy chart, and he really lowballs the life expectancy. But included in that chart, there's also a 51% factor. So if you live to be a certain age, you have a 51% chance of living longer. So I use that sort of like a more probable than not standard in my case on cross-examination for him. Ultimately, Dr. Shu, the treating pediatric neurologist, and Dr. Schumann, they were sort of close about where they thought she would be, maybe in her 50s, mid 50s to early 60s, how long she would live. And that's important because you never want your client to run out of money when you have this bad of an injury for that nursing care. So we wanted to take this, we fought hard on this, and this was a very important part. Ultimately, the jurors came out with about in the 50-year range, which I think was a reasonable result. Now I'm going to hand it over to Ivan to talk about the cost of the nursing care and how we had to deal with that issue.
The nursing care was undisputed that she was going to need 24-hour care for the rest of her life. This was a huge issue in the case because if she got that care from an agency, the cost, according to Carol Highland, our life care planner, was $41 per hour. If she went without an agency and did what you call the cash rate or the Medi-Cal rate, it was around $20 an hour. And taking that over the span of the life care plan, that was a swing of about $10 million in damages, depending on whether the jury went with the agency rate or the non-agency rate. So there's a lot of factors that we looked at in terms of why an agency rate was better. Fortunately, her pediatric neurologist recommended an agency. The difficulty we had in the case was that she had been not using an agency up till the point of trial, and she actually loved her attendant care person. She was great and doing a fantastic job for $20 an hour. But there's advantages to having an agency, and we went through all those advantages, and some of them were, with an agency, it's a legal arrangement. You've got benefits, you've got workers' compensation. Without that, it's, we argued it's a quasi-illegal relationship under the table. Nobody's paying workers' comp, even though you have this full-time employee at your house. The parents would be left with the responsibility of hiring and firing people instead of the agency. And the fact that the workers not in an agency don't get benefits, there's going to be more turnover. And with more turnover, you get less continuity of care, you get poorer quality of care. Someone could be sick. And now we're in a post-COVID world. Had we done this trial today, I would bring up COVID and talk about the fact that if you've got a attendant who is either sick or taking care of a loved one and can't risk an infection, they may call in sick. or given Isabella's condition, she can't be exposed to any germs or potential virus. So if your attendant even has a sniffle, they can't come into work. So if you don't have an agency, what are you going to do if they call in sick? An agency, it's always next man up, next woman up. There's always going to be someone there for the rest of her life. So looking at all these factors, it made sense to go with an agency. And the defense expert, Ed Bennett, on this issue, he was pretty reasonable and agreed that he had no problem with the family using an agency. Here's his trial testimony on that. And he was asked that even though he used a different approach and had a different number, he didn't have any opinion that the figure that Carol Hyland came up with, the $41, is inaccurate or unreasonable. He said, no, it's not inaccurate or unreasonable for $41. So if you can say it's not unreasonable, that's pretty close to reasonable. We had to brief this issue too because the defense, of course, wanted to bring in the fact that Miss Phillips, the LVN who'd been helping Isabella for the last several years, she was paid $20 an hour through Medi-Cal. And under the Corazon versus Lampkin case, and the cites in your materials, evidence of the full amount billed for past medical services cannot support opinion of the reasonable value of future medical services. So that's exactly how the defense wanted to use it here. They wanted to use evidence of what was billed for Miss Phillips to say what's a reasonable amount to pay for the future. The Corazon case is on point. It says you can't do that. So they were not allowed to talk about the fact that Miss Phillips was getting paid $20 an hour at the time of trial. And the court allowed evidence of the reasonable value of future services to just come in through both sides' experts. In the end, the jury awarded a life care plan based on the $41 an hour rate. And just a quick tip, we do this in all our cases, a lot of people do, but if you're not doing it already, have your experts write their final opinions on a piece of butcher paper and then photograph it at the end of the day, and then you can stick that photo into your closing. And it's just a nice summary, and it feels like the opinion's not coming from you, the lawyer. The jury's reminded of what that expert wrote on the board while they were testifying.
And then I think our last that special and jury instruction. This is another thing that I've been doing more often now in cases, is that if you have a large damage award, the jurors want to know where that money's going. And what we did is we had our economist talk about the fact that in cases like this, any judgment rendered has to be monitored by the trial court as the guardian ad litem, and there's special needs trust involved, and there's people that manage the money for the little girl throughout her lifetime, so that they don't think that, oh my goodness, are the mom and dad going to get all this money and whatnot. So it takes that issue away. So this special instruction we have here was granted. I think it's a good thing to use in a lot of cases where you have this situation, especially when you have a minor plaintiff, where there's going to be a lot of money involved with that minor plaintiff, that it's going to be all supervised by the court. And I think it gives the jurors comfort to know that.
And in addition to this instruction, you can ask your economist, is it your understanding that the money awarded by the jury, if any, will be monitored by the court and administered through a trust or whatever the case is?
Right.
So I think we're wrapping it up here. We just wanted to show one video that we showed at trial of Isabella doing her physical therapy.
And I want to give a shout out to Kelly Deutsch from Verdict Videos. She did this video. Kelly and Mark.
You chose yellow. Okay, here we go. There you go. I see you thinking and looking at it. Okay, you have to make it. Yay! You did it that time. I'm so proud of you. You got 2 points.
So with that, I hope that that last clip kind of shows the importance and the magnitude of this case and why we were all so passionate about getting full justice, as Jeff said, for this little girl. And as I mentioned before, this is really a case that we feel defines our firm and what we're all about. We have gotten a few questions here, some interesting questions. One of the questions is actually from a law student asking about some career advice. And I'll just respond to that since I'm probably closest in age on the law school thing. I'd be happy. One of my favorite parts of my job is to work with mentoring law students and helping them in their careers as they're starting off. I had a lot of people help me along the way, including the partners at Greene Broillet. So you're going to get our email addresses here at the end in a slide coming up, I believe. And any law students who'd like to reach out for advice, I'd be happy to do a one-on-one Zoom or a lunch once this COVID situation is all over to answer any questions related to that. Also, Jeff, I'll push this question over to you. This is a great question. If life expectancy is shorter due to the injuries, isn't that compensable too? Why not agree that life expectancy is shorter, as the defense expert testified to, and then ask for more money for that shortening of life?
Yes, you could do that. The situation we had here was that we had, I think it was $400,000 or $500,000 a year in the agency-rated LVN care. So an extra 10 years, 15 years was millions of dollars of economic damages. And when we're out in these more remote jurisdictions like San Bernardino, I feel like the jurors respond better to the economic damages than they do to the human damages, the general damages. So that's why I fought for that. But yes, definitely, the fact that you put her in a chair and shortened her life, you shouldn't get a bonus for that. You shouldn't get a break for that. That's absolutely right. You can make that argument. In this case, I think they awarded about $15 million in non-economic damages, which, you know, that was a little light, I thought, for what she'd been through. Maybe it was 20 million, a little light for what she's going through. But again, that we wanted to boost those economic damages, so that's why I did it that way. But that's a great question.
And just one more question, Jeff, before we wrap up. Obviously, there's a lot of issues going on in this case, a lot of strategic decisions that you and Ivan had to make as to how best to argue this case once the evidence was in front of the jury. Could you elaborate a little bit more on your closing argument strategies and what you did? And by the way, Jeff's closing is going to be posted online on our website. You can see it on the handouts in the right side corner of this screen that you have here. And I'd highly recommend that all of you go check that out and take a look. I know I took a lot away from it, but Jeff, if you could elaborate on that a little bit more.
Sure. So one of the things that I did was I talked about the fact that we had the two rules, which were basically the theories of negligence in the case. And we only needed to prove one of those violations, but we proved both of those violations. And we proved that not only through our own expert that came in and talked about what the driver did or should have done and failed to do, but we proved that through their own driver training people that admitted that they had violated the rules. And we proved it through the police officers, investigating officers that were, you know, objective officers, that they thought it was more likely than not the bus was there without the red lights on. So I tried to polarize the case and show that what is the defense for this? That we didn't see her, therefore it wasn't happening? I mean, that's the testimony. And we would pull up those killer graphics showing the line of sight from the mailbox to the bus and the bus to the mailbox. And, you know, I just think that it's almost an exacerbated case of liability when you pulled up that calendar and showed how many opportunities they had to fix this. And I mean, I felt like I had to apologize to the parents that were sitting in the courtroom that we were even there, that we should never have been there. If people had followed the rules, we shouldn't even have been there. And they were doing an amazing job. The dad, which we didn't have testify, he's an amazing guy. You know, he used to, before we got this recovery, he used to have to pick her up out of the wheelchair and put her in his truck That's how he transported her. You know, it's unbelievable. And she's like over 120 pounds now. Now they have a van, they got a lift, they have one of these great Sprinter vans and whatnot. So I think by polarizing the case and showing that we were bringing them the truth, and they really weren't accepting responsibility at all for any of their actions, put them in a very tough position, because they couldn't really argue that it wasn't happening. I mean, the testimony was just over. It wasn't more likely than not. It was beyond any doubt in this case. So that's how I approached the closing argument. I did do a yearly humans damage argument. I asked for between $750,000 and $1 million per year, which was, I don't know, 50 or 60 million dollars I offered. Then in the end, they went at 36 because again, these outlying jurisdictions were outside the courthouse. Within a block of where we are, there's people living in their trucks and tents in the river outside the San Bernardino courthouse. You know, if you're going to be asking for too much money, you run a risk there of losing credibility on the other side. That's my feeling, my opinion. I'll have Ivan, you can give your 2 cents too.
I think Ivan's trying to create a little slide on the
I
fly.
was.
I do have one more question for you, Jeff.
Right. Okay,
go
I
ahead.
was just trying to put the emails up there.
Yeah, Jeff, if I know that you and Ivan got very close with Isabella and her family throughout the case, and still close to this day. And I think some of the attendees on the webinar probably are curious and wondering, how's Isabella doing? Are you still in touch with the family? Because really, this case is all about her and what kind of care is she able to get as a result of this?
Yeah, that's a great question. So her mom sends me a text or a picture about every 3 or 4 months. And she got a bone flap put in about a year ago. She got a bad infection again. They had to take it out again. And then they put it recently back in. And her mom sent me this picture. I don't know if it'll show on the computer or not. She went to Disneyland before COVID. She has her bone flap in. And, you know, she's a remarkable girl that when she touches you with that hand, it changes your life. I mean, and she will look you in the eye. She can't talk. She will look you in the eye and she'll grab your arm, your forearm with that hand, and it changes your life. It changed my life. This case changed my life as a human being and as a lawyer for sure. I'll never forget this case. And this little girl, I have her picture up on my wall. I don't know if you can see it up. I have her picture. That's when she graduated 6th grade. But I see her every day that I'm in the office, which isn't every day now, but I think about her every day, and I think about her when you get tired or when you want to give up on a case. Think about who you're fighting for and why you're doing it, and it'll keep you going, man.
And with that, I mean, that's really what it's all about, right? That's why we all do what we do and why we're passionate about what we do. And with that, I'd like to conclude this webinar. All of us here at Greene Broillet Wheeler really appreciate everyone taking the time to spend their morning with us. It was great to have everybody on. If you want to contact us, you can find all of our information on our website. But if you have any questions, I'll just throw out my email. It's cnickerson, Nickerson @gbw, G as in green, B as in boy, W as in wheel, .law. And our firm's all about sharing. So if there's anything that we can do to help you, or to send you sample motions or sample discovery, or if you just want to chat about a case, we're happy to do that. And I also want to mention that in 2 weeks, as I mentioned, this is our bi-weekly Method for Success program. We're going to be doing another webinar, which I hope you'll join us for. This webinar is going to be a little different in 2 weeks. It's on a whistleblower retaliation case on the Pedowitz versus UCLA matter. You can read about that LA Times article regarding the result of that case. But we're going to be presenting on that, and that resulted in a $10 million result for our client, and also, interestingly, a letter of apology from all of the defendants. So I think that you'll take a lot away from that. And with that, we'll conclude, and we hope to see you all again in 2 weeks, and hope that you're all staying safe and healthy. Thank you.
One thing, Jessica posted our 3 emails. on the chat function here if anybody wants to reach out or has any questions. Thanks, everyone.
Oh, and one more thing. Also, this webinar was recorded. It'll be up on our website if you want to go back and review that along with the other materials. And with
Okay.
that, I think we're done.
All right. Thanks, guys.
Bye-bye.